Hi, my name is Amanda Cardona. I am an associate practicing in the Chemical and Material Science group at Lando Anastasi. In this short video, I will provide an update on proposed federal regulations impacting intellectual property rights that should be considered by organizations and in-house counsel as they review their IP protection guidelines. Specifically, this video will touch on the draft guidance on the exercise of march-in rights, new reporting requirements on inventions arising out of federally funded research, and the proposed federal regulation on non-compete agreements that would impact the protection of trade secrets and proprietary information. Under the Bayh-Dole Act, recipients of federal funds are given the right to own inventions that arise from federally funded research. Government agencies, in turn, retain the right to march in and force licenses of these federally funded inventions when the circumstances require increased accessibility to the technology, such as for health and safety purposes. To this day, march-in rights have never been exercised. The National Institute of Standards and Technology has now undertaken the preparation of a guidance on march-in rights in an effort to provide greater clarity on the metes and bounds of such rights, as well as summarize scenarios when these rights might be exercised. Last year, the NIST released for public comment a draft guidance. Under the draft guidance, before exercising any march-in rights, agencies would be directed to demonstrate that the Bayh-Dole Act applies to the invention, whether march-in rights are warranted under the circumstances, and whether exercising march-in rights would further the policy and objectives of the Bayh-Dole Act. The draft guidance also lays out a procedure for exercising march-in rights that includes the requirement for the agency to provide written findings of fact, allow the patent holder to submit arguments in response, and appeal any decisions to the U.S. Court of Federal Claims. The draft guidance is open for public comment until February 6, 2024. Practitioners are concerned that this new guidance will result in federal agencies inappropriately attempting to control or regulate market prices. For now, the draft guidance can be found on the Federal Register. The NIST also operates the platform iEdison, which recipients of federal funds must use to report any subject invention developed with the assistance of granted funds, as well as to report on the progress of any patent protection sought for these inventions. Recipients of funds are now also required to report annually on the utilization of federally funded inventions by completing a questionnaire on all licensing and commercialization efforts of these inventions. The exact questions will depend on the current status of the technology. However, possible questions include commercialization plans, amount of income received, number of licenses or options recorded, names of products developed, and names of the manufacturer of products, as well as where these products are manufactured. The new questionnaire raises concerns about the burden of collecting and reporting this information, as well as the possibility that recording and reporting this information could impact relationships with partners, licensees, and manufacturers. Any finalized guidance on the exercise of march-in rights will be of significant concern for organizations and in-house counsel as we move into 2024. Organizations may want to pay particular attention to their commercialization and licensing efforts of inventions arising out of federally funded research. At the beginning of last year, the Federal Trade Commission proposed a regulation on the enforcement of non-compete agreements that is considered to be an outright federal ban. Many entities have publicly opposed the proposed regulation. The FTC has not yet indicated when it will be implemented, but when it does, it is expected to face challenges in court. While it is unknown whether a federal ban on non-compete agreements would pass scrutiny in court, it is notable that many states have already begun implementing local laws that heavily regulate non-compete agreements. Antitrust claims have also recently been used to challenge restrictive covenants, such as non-compete clauses, in court. So what are the IP implications of a ban on non-compete agreements, and what should organizations and in-house counsel do to prepare? Non-compete agreements are used as a tool to protect trade secrets and know-how from reaching the hands of competitors by preventing employees who developed or worked on the company's trade secrets from accidentally divulging this information for the benefit of a competitor for an appropriate period of time. In the current legal landscape, non-compete agreements remain valuable. However, they should be used in compliance with existing applicable laws and regulations. Furthermore, they should be reserved for those employees who not only have access to confidential information, but also possess the knowledge to use this confidential information for the benefit of a competitor. Given the potential for non-compete agreements to be deemed unenforceable, employers should also implement additional tools to help protect their trade secrets, such as confidentiality agreements, employee education tools about the protection of confidential information, and consider siloing different aspects of confidential information among different employees. Furthermore, employers should keep in mind the data privacy implications in the age of remote work. Throughout 2023, several legislative initiatives impacting intellectual property rights were proposed. The ones that I summarized in this video will be of significant concern for organizations and in-house counsel as we move into 2024. In view of these proposals, organizations may want to pay particular attention to their commercialization and licensing efforts of inventions arising out of federally funded research, as well as revisit their policies regarding employee agreements and education in support of trade secret protection. I'm Amanda Cardona. Thank you for watching.